Why is EagleView suing everyone? EagleView got a $125 million payout from XACTWARE and VERISK. They also have active cases against ROOFR and GAF. So what has made them successful in the past, and will they continue to be successful? That's what we're going to try and answer today. Part 1. Who is EagleView? To understand what is going on with all these lawsuits, you need to know a little bit about who EagleView is. They are known for their aerial measurement technology, which is used by the construction and insurance industries to create bids for clients. If you have been in roofing for a while, then you know that this is a big deal because it is much faster and more accurate than measuring by hand. Now, EagleView is not the only company doing aerial measurements, but they are the biggest one. So how did they become the leader in this? They came onto the scene early, and they got patents for their technology. EagleView was founded in 2008, and on October 31st of that year, they filed 2 provisional patents for pitch determination systems and methods for aerial roof estimation, and concurrent display systems and methods for aerial roof estimation. This is the first step in the process, and it basically just means, hey, we invented this, but they are not official yet. 2011 is the year they get their first issued patent. So this is the first time they have an actual legal claim against anyone else using their technology. Now, we're not going to go through when they get all their patents because there are a lot of them, but there is one more big event in their history. In 2013, EagleView announced a merger with Pictometry International, the leader in geo-referenced aerial image capture and visual-centric data analytics. Pictometry was a competitor to EagleView, and they had actually been around for longer, since 2000. Pictometry had their own patents, and so when the merger happened, they brought these with them. And the CEO of EagleView took over the new parent company, EagleView Technologies. Today, the EagleView website lists hundreds of active US patents, and they have even more that are pending. It is those active patents that are at the center of all the EagleView lawsuits because those are what give them intellectual property rights and a legal claim against anyone else selling those products.
This video is sponsored by Directory.com, the safest way to find a roofing contractor. Directory app is free to use, and all contractors and their jobs come with a $20,000 guarantee. Directory is a concierge service. They find and recommend contractors to use for your home improvements projects and back them up with their own money up to $20,000. In a rare case, when contractor takes your money and runs away, Directory will pay you your money back or will finish the project if contractor disappears or ghosts you. Directory does not give bad recommendations, but in case of a dispute, you are covered with a $20,000 guarantee. Download the app now and hire your next contractor with a peace of mind.
Part 2. Past lawsuits and precedents. So who has EagleView gone to court with? EagleView has sued 8 companies for patent infringement, including ROOFR, and they have been sued once themselves. This record is important because every time they win a case, it sets a precedent that they can use in future lawsuits alleging similar allegations. GEOSPAN versus EagleView. We'll start with the one case where EagleView was actually sued for patent infringement by GEOSPAN in 2013. GEOSPAN has been around longer than them, since 1992, and they claimed that EagleView was using a technology that they invented in 1997. The 946 patent, method and apparatus for collecting and processing visual and spatial position information from a moving platform. The key part of this technology is the dual 2-camera image collection process. GEOSPAN had previously sued Pictometry over this patent before their merger with EagleView, and failed. In that case, Pictometry argued that they were only using a single image to take measurements, and so a judge dismissed GEOSPAN's claims. But in 2013, GEOSPAN says Pictometry, and by extension its parent company, EagleView, are now using multiple images to take measurements, and so they sued again. This case was ultimately settled in 2015, and those terms are sealed, and presumably a payout or business solution forward was reached. EagleView versus ROOFWALK and EagleView versus AERIALOGICS. EagleView has sued and settled cases against 2 other companies for patent infringement, ROOFWALK in 2012 and AERIALOGICS in 2015. Now, like with GEOSPAN, the terms of these settlements are sealed, but it's likely that both defendants had to pay EagleView for using their products. And that would make sense, because both companies started after EagleView. ROOFWALK in 2011 and AERIALOGICS in 2010. As far as we can tell, as of 2014, ROOFWALK is no longer operating. But AERIALOGICS is still around today and could still be paying ongoing royalties. You can look at these settlements as wins for EagleView, but when a case is settled, it is dismissed by the court. So they can't use the fact that they settled these previous cases to make arguments in other lawsuits. EagleView versus XACTWARE and VERISK. EagleView's first big win in court is against XACTWARE Solutions and VERISK Analytics. In 2015, they sued both companies for infringement of 6 patents. After a 12-day trial in 2019, a jury found XACTWARE and VERISK liable for willfully infringing EagleView's patents and awarded EagleView $125 million in damages. The U.S. District Court of New Jersey then ordered a permanent injunction against XACTWARE and VERISK to stop them from using EagleView's technology. In her opinion, Judge Renee Marie Bum wrote, "The defendants announced in their formal written business strategy that they viewed EagleView as a threat and so set out to aggressively erode EagleView's market share and undercut EagleView's prices. XACTWARE and VERISK have since filed appeals and have been denied. And all of the patents involved in this case are now strengthened because the judge affirmed that they are patent-eligible material, setting a precedent for future cases." So what does that mean? We can get a better understanding by looking at EagleView's next lawsuits: EagleView versus GAF and EagleView versus NEARMAP. In 2021, they sued GAF in the New Jersey District Court for infringement of 9 patents, and 3 of those already had a precedent from the XACTWARE case. In response, GAF filed a motion to dismiss the case based on the argument that EagleView's patents are invalid because they are abstract ideas. Under U.S. law, you generally cannot patent mathematical equations, laws of nature, living things, and abstract ideas. There is a 2-step test established by the Supreme Court to determine whether something is non-patentable in these types of cases. In step 1, a judge looks at whether the patent infringement claims fall under one of those 4 categories. If not, the test ends and the case moves forward. If they do fit one of those categories, then it goes to step 2. GAF argues that 9 EagleView patents fail step 1 because, among other reasons, they are directed to the abstract ideas of automated image retrieval, 3D model generation, feature indication/model modification and image display/registration, pitch determination and model modification, and pitch determination. The New Jersey court did not address the merits of GAF's arguments to dismiss the case because the judge transferred the case to Utah, where EagleView has filed a separate lawsuit against NEARMAP. Basically, the New Jersey judge agrees that the court in Utah is already familiar with those patents, and so it makes sense for them to decide both cases. GAF renewed its motion to dismiss the case in Utah. However, the court declined due to its determination that the case required further proceedings before deciding GAF's arguments. Both cases remain in litigation in Utah. Part 3. EagleView versus ROOFR. In 2021, EagleView filed a suit against ROOFR for infringement of 2 patents in the Delaware District Court. And then in 2022, they actually amended their complaint to include 3. The 840 patent, pitch determination systems and methods for aerial roof estimation, the 538 patent, method and system for quick square roof reporting, and the 800 patent, system and process for roof measurement using imagery. Now, just like in the XACTWARE and GAF cases, ROOFR's first move is to argue that these are not actually patentable ideas, and they ask the court to do the 2-step test. We know that the 840 patent was already determined to be patent-eligible material in the final ruling of the XACTWARE case, giving it a strong precedent. The 800 patent and the 538 patent have not been litigated before, but this is where it gets complicated. Each of these patents is made up of a series of claims. When EagleView sues ROOFR, they point to specific claims within each patent, saying these are the parts of the product that ROOFR is stealing. When ROOFR asks the court to do the 2-step test, they make the majority of their argument against the first claim of each patent. And they say that this can be used to represent the whole thing and determine whether it is patent-eligible material. In January of 2023, the court responds to ROOFR's argument, and they say yes, actually Claim 1 of all 3 patents are abstract ideas. You can't patent these. So then it moves to Step 2, which asks whether the claims contain an inventive concept which is sufficient to ensure that the patent in practice amounts to significantly more than just an abstract idea. And again, the court finds that Claim 1 of each patent fails this test. So it's a win for ROOFR, right? Kind of. The court says we agree with you that Claim 1 of each patent fails, but you're going to have to prove that every other claim under the 800, 840, and 538 patents do not pass this test. There are 63 claims in total. In March of this year, ROOFR submitted its full argument against all of these claims and asked the court to make a judgment on whether they are ineligible. But they also petitioned the U.S. Patent and Trademark Office to do an inter-parties review and look at whether one or more claims of 800, 840, and 538 are not patentable. As of right now, the EagleView versus ROOFR case is stayed until at least August 9th, 2023, so that review can happen. Part 4. Will EagleView continue to succeed? So, will EagleView continue to win? It's hard to say. They do have some strong precedents for the 840 patent, and 840 is involved in its pending cases. But other patents in those cases have not yet been tested, so it is anyone's guess what happens with them. And with the Trademark Office reviewing the 800, 840, and 538 patents for ROOFR, it's possible that EagleView could lose some of its patent power, even with its past wins. If EagleView loses the 840 patent, pitch determination systems, and methods for aerial roof estimation, that would be a really big deal, because it has come up over and over again in these lawsuits. And it is one of the first 2 patents they filed as a business. It seems to be at the core of a lot of their technology. So we will keep you updated on what happens next.